Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined today, as always, with the co-managing partner of our Boston office, Miki Matrician. How are you doing today, Miki?
I'm okay. How are you, Kim?
I'm doing good, thanks. All right, so today we're going to discuss some more information about a topic that typically arises this time of year as employees that have optional and practical training start to ask employers to assist them with the application for their STEM OPT extensions. So, why this time of year? Well, most STEM OPT extensions are prepared and filed this time of year because it's typically filed up to 90 days before the OPT expires, which is the optional practical training. And the optional practical training usually expires somewhere between May and July, which is based on graduation from the advanced or secondary degree programs in the United States. So, what exactly is STEM OPT extension? Well, STEM stands for science, technology, engineering, and mathematics. And the F1 students are eligible for STEM OPT extension if they graduated from a US university or college with a STEM degree. So, if their major field of study is something that's considered by our Immigration and Customs Enforcement as being covered under science, technology, engineering, or mathematics, and they're eligible for this additional time, which can be up to 24 months after the end of their OPT. So, Mickey, very often an F1 student will say that they have 3 years of OPT to work after graduation. And it's not exactly accurate as there are, two distinct periods of time. The first, which is optional practical training, and then the STEM OPT extension can kick in. So, can you discuss for our global mobility and HR professionals some of the differences between these two programs?
Sure. So, in general, F1 foreign students may have up to 12 months of optional practical training upon graduation from their degree program in the US. And the student works with their designated school official to be issued the optional practical training endorsement from the university towards the end of their degree program. And then they file the application with US Citizenship and Immigration Services, and the student is then issued the employment authorization document. That EAD is evidence of their authorization to work in the US, and they can work for any employer in any location in the US in full time or part time. They do have to work in a job that's directly related to their field of study, and the employer is not required to sponsor the individual or submit any documentation to support the OPT, just the university DSO's endorsement. It's important to know for the OPT that they do have to have the EAD in hand to start working for their employer post graduation. And then STEM OPT is a little bit different. It's important for global mobility and HR professionals to know that an employer does, in fact, need to sponsor an individual that obtains the STEM OPT. That STEM extension is good for up to 2 years beyond the end of the OPT period. And unlike the initial OPT, the individual can continue working while their STEM extension is pending with immigration services, so long as that application was filed before the expiration of the OPT.
Right. So, we're throwing around this term that's called sponsor, and that can be taken differently by different individuals. But, what does the word or the term sponsor by an employer mean in this purpose, Mickey, for student STEM OPT?
Yeah, so what mobility and HR professionals need to know is that for an employer to employ an F1 student under the STEM OPT, the employer has to be enrolled in E-Verify. And if an employer is not already enrolled in the E-Verify program, we recommend that they discuss with their counsel their obligations and requirements to participate in E-Verify before they enroll in that program. There's no fee to enroll in E-Verify, but there are initial and ongoing requirements for employers that do need to be considered. And then, in addition to being enrolled in E-Verify, sponsorship for the STEM OPT means that an employer is required to complete with the employee the Form I-983 student training plan. And what that training plan is it includes a section about the foreign national's biographic information and STEM degree, but there's also a section for the employer to provide information about the company. and also to be completed by the employer to explain information about the work site location, the duties, the goals and objectives for the employment, and what skills and knowledge from the STEM degree will be utilized to perform those job duties. The plan also needs to include a description about how that F1 worker will be managed and how performance would be measured and assessed. It's also important to know that the training plan requires that the employer employee complete an evaluation at the end of the first 12 months. And then again, at the end of the employment period, which is either at the end of the 2 year STEM period or when that STEM OPT employment ends, if that's before that 2 year period. And then the employer also has to certify that it has sufficient experienced and knowledgeable personnel that will properly execute the training program for the F1 individual as presented. And then we recommend that employers maintain an audit file with the CVs of the employees who are involved in the F1 student training. And also, the employer has to certify that there's no temporary or permanent full time or part time US workers that would be displaced by hiring that F1 worker. The employer is not obligated to perform a labor market test or, to demonstrate the unavailability of US workers, but the employer does have to confirm and has to be prepared to show that the hiring of the F1 student didn't directly result in loss of existing or prior employment of US workers. And then the employer has to also ensure that they are providing compensation that is commensurate with that of similarly situated US workers, including their salary, bonuses, and other types of benefits or remuneration like stipends or tuition waivers. Finally, employers are also required to notify the relevant university DSO anytime there's a material change to the training plan. And what material changes can include are things such as change in job title, job location, reduction in work hours, or even corporate restructuring, for example, if the employer adopts a new FEIN. So, turning to you, Kim, some of our other rapid fire Wednesdays we've discussed included increased enforcement action expected by government agencies with respect to H1 programs as well as STEM OBT programs. Can you tell us a little bit about what this means for employers that have STEM OPT workers?
Yeah, sure, Mickey. And when you were talking about all of the things that employers have to essentially keep in an audit file, right? That's a lot that employers need to do more so than just the regular optional practical training. So that's, the other part of what we consider, sponsorship because there is a huge part on the employer to make sure that they're abiding by the SMOPT regulations and these various requirements. So it's really important for our global mobility professionals and HR professionals to know that as you were talking about, there are these additional requirements when employing somebody with the STEM optional practical training. And specifically, the rule does provide authority to Department of Homeland Security to conduct random site visits. So that's in order to ensure compliance by the employer with respect to their engagement in the STEM OPT process. So typically, the government is required to provide 48 hours notice of such visits unless there is a complaint or other evidence of noncompliance, which is the result or the cause or the reason for that visit to be undertaken by the government. And, this site visit could come in the form of an on site meeting, an email request, or even a telephone interview. So typically, the site visits are conducted by Immigration and Customs Enforcement, and they might involve the US Department of Labor because of that. It's not a prevailing wage requirement, but there is that requirement to make sure that essentially these individuals aren't being brought in as cheap labor, right? So that's where Department of Labor could potentially be involved. And then, with this relatively short notice being provided by the government, we really do recommend to employers that they be prepared and keep evidence of their compliance with this MOPT program and make it easily accessible, right? So they can gather this information and have it available to present to ICE when they do reach out and request it. So this means, basically creating and maintaining an audit file that would contain a copy of the fully executed I-983 training plan, as well as supporting compensation information that was used to ensure that the student is being paid that commensurate wage. Include the student evaluations that need to be completed with the STEM I-93 training plan. And as Miki mentioned, the manager's credentials, which would be their CV, and then a non displacement report for US workers, basically showing that a US worker wasn't displaced in that area of intended employment because of the hiring of this STEM OPT worker. So those are, the main documents to keep readily available in case of an audit. And then just one other thing, we were talking about in a company that might already have an employee that's on OPT and is switching to STEM OPT. But we also see around this time of year some instances where individuals are changing employers and they're going from STEM OPT with one employer to STEM OPT with another employer. And it's just really important to remind, our HR professionals that there's a training plan that needs to be submitted to the designated student officer within 10 days of that change of employment. So that's another thing to keep in mind and make sure that that's maintained in the audit file as well. So I think with that, it's a wrap for today's session. And for our previous discussion on the F1 visa stamp revocations and terminations of SEVIS records, which does play in with a SEVIS OBT extension, please see our Rapid Fire Wednesday that we did on April 23rd. And then, of course, stay tuned for future episodes on updates to the immigration landscape. And if you don't already, please follow us on our LinkedIn for WR Immigration, as well as our individual profiles. And we also transcribe each and every episode of Rapid Fire Wednesday and post it to a weekly newsletter that you can subscribe to. And the link to subscribe will be in the video description. So until next week, good to see you, Miki, and have a great one.
Thanks, Kim. Good to see you.